And Dee Barnes?
Yes.
Hi.
Hi, how are you?
I'm great. Welcome.
Thank you.
Thanks for joining us.
We're just testing this Zoom out. This is the first time we've used it.
Yeah, and we'll cover a little bit at that beginning too, so don't worry about it.
Okay. Are you going to mute us?
I can mute you all. Yep. I won't do that until there's too many people and it starts to get obnoxious, but it's a good chance for you to test it out.
Okay.
I would also say if you have video capabilities, which it looks like you do, in the bottom left-hand corner of your screen is a mute button and then a video button.
Okay.
And you can use either of those to activate your video or your audio at any time.
Okay, perfect.
Okay. I won't make you, don't worry.
Okay, good. Thank you.
Yeah. It's one of those funny moments where we can say, who's wearing pants today?
I know, right?
It's true.
I've got my day pajamas on.
Welcome, everybody. Thanks for joining us. What we will do is cover some high points today and really seek to address as many questions as we can, because I think this time that we're in, this unique time, is prompting an unbelievable amount of questions. It won't surprise some of you that we won't have all the answers, but what we'll want to do is, one thing we want to do today, I'll say it right up front, is to the degree we collect questions and questions come up that we can't address in the time allocated, we'll happily partner with the chamber to send something out and address some of those other questions. So don't feel frustrated if yours doesn't necessarily get our attention today. There's a lot to cover. I'm going to get underway and cover some of the issues, and then my colleague Dan Stockford, who works with me very closely, is going to have the task of explaining the new federal law to you at a high level and tell you, the type of advice we're giving to clients as we speak. We also have put out a number of alerts. They're available, I think, through the chamber. We can send those alerts to you directly as well. Just to give you a flavor of how quickly this is moving, the alert that I believe we either have just sent out or send out in minutes is really on a topic that none of us want to see and face and deal with, but it's layoffs, and in particular the WARN Act. And I'll touch upon that in a little bit, but we're sending out quite a lot of information on the WARN Act, because that's something that if you're looking at layoffs that impact more than 50 employees, you'll want to at least be considering. There's way more detail than probably today allows for that discussion, but just give you a heads up on that. On March 9th, we sent out our first Q&A on this topic, and I look back at that now, and it already looks somewhat redundant. Some of those issues remain issues you're tackling, but there's been a shift from clearly March 9th to today. But let me just very high level tell you what I want to sort of cover with you. I want to talk about the what ifs in the workplace right now, the questions that we're getting, and give you sort of our practical judgment and common sense on that. Then I want Dan to be able to walk you through some of this emergency paid leave and the extension of the Family Medical Leave Act, and then tackle questions. So, one issue that we are advising clients on a lot is that this is a time where, and this may sound simplistic, but I think having a high level review of all of this is helpful. We say to clients when they call us and they're faced with competing risks, we give the advice that if you are fundamentally motivated by safety, if the decision you're making is one that promotes safety first and foremost, you're in a good, solid place. And I'll give you a concrete example. Many of you are in HR, and you'll be familiar with the ADA and the ADA's protections of employees, appropriate protections that relate to confidentiality, protections that relate to medical information, all of those rights that are not suspended under the ADA, But in this time, when I'm faced with a question which has to balance the ADA rights of an employee and the safety of the workplace, we may be tilting more towards the safety of the workplace than we are specific ADA rights. And that comes down right away to issues that I think now we're all pretty much in the same place, but I want to go over at a very high level, which is, in the first place, yes, we do have an ability as an employer to ask people to stay out of work. You're doing that already. I know I've got calls from clients, and some of you are on this Zoom meeting where we've asked people to stay out. And my advice to people has been, if you're in any doubt about whether somebody should stay out, I would in fact place them out of work, direct them to stay out of work. Clearly, the cases where somebody has symptoms that would be consistent with coronavirus are an obvious example. Very early on, we faced questions, and we continue to face questions about employees who believe that they have had some degree of exposure to somebody who has been tested positive for coronavirus. I'm not a medical expert. I can't tell you the degrees of separation that would lead you to say, yes, come into work, or don't come into work. On those issues, you're going to have to use your best judgment. And again, if you have doubt, I would err on the side of caution. Initially, when we were giving the first round of advice on this, we were giving advice relating to whether or not you should require a medical note when an employee is able to return to work from a self-quarantine or an imposed quarantine. And the advice I continue to give is, yes, it would be ideal to obtain a medical note. Whether in fact that will be practical now or in the future is far from clear. Just so I'm clear on this issue, the CDC suggests to employers that they do not obtain a medical note, and they don't do that because they don't think it's worthwhile. They do that because they fear that the medical system will be swamped by the need for medical notes. So I'll tell you the advice I'm giving when I'm getting calls is, when someone says the person's scheduled to return to work, should I just take them on good faith that they no longer have symptoms? Should I take them on good faith that they've been out long enough? Should I take them on good faith that they don't have the coronavirus? I'm saying, in today's brave new world, ask questions that you would not ask of an employee in typical times. I believe you ask employees, do they still have symptoms? Do they have a temperature? How long have they been out? Where have they been? You're going to know the right balance between being overly invasive, but this is not a time, I think, to be shy about asking those questions in an appropriate and respectful manner. The EEOC, the federal agency that oversees compliance with the ADA, remained silent for a long time, and then I'm losing track of time, but either at the end of last week or over the weekend, I think it was the end of last week, they came out, and we've circulated some information on their guidance, and it really was a dramatic shift for the EEOC from where they stood before. They previously were very cautious in their advice, and they had given advice back in 2009. This time they're saying, I'm putting this too simplistically, but in essence they're saying, let your safety and your medical needs and inquiries prevail over ADA rights. That's a high level, somewhat simplistic statement, but you can read the EEOC guidance for yourselves. It's right online. They've gone so far as indicating that in this current pandemic, and of course it now has been declared a pandemic, that employers may, if they wish, take the temperatures of their employees. We had a question just last week about whether an employer could require their employees to wear face masks. And my answer, of course, not of a medical nature. I wasn't opining on the efficacy of doing that, but from a legal point of view, gave the opinion that an employer could make that a requirement if they felt that it was necessary. I said if they can get medical guidance, so much the better. So those are a flavor of the medical issues, the doctor's notes, the quarantine issues that we're facing. I'm going to move on quickly to talk about confidentiality, and then I'm going to have Dan talk about these new laws, because I suspect, seeing the number of participants out there, that's what's front and center for a lot of you. So let me just talk about the confidentiality. You may have already faced this issue where you have an employee who either has tested positive or is showing all the symptoms of coronavirus, and in fact, maybe in a situation where medically they've been advised not to be tested, or the test has not been available, but they're receiving information from the medical provider that they should treat themselves as if they are infected. The confidentiality provisions of the ADA still apply, and an employer should not be notifying other employees about the identity of that person. We have given advice in some situations that if the infected employee consents to the disclosure of their name, then your risk is greatly diminished in disclosing that information. The clients, and we've had a number of them now who we've walked through this process, we certainly recommend, and certainly government agencies recommend as well, that you must inform the employees in the workplace where the employee worked of the infection or the suspected infection. We've given advice that you should or could inform employees of the dates that person worked. In the instance where that person has worked with a smaller group within a larger facility, I know our client in that instance had meetings with that smaller group to inform them, again, without identifying the name of the employee. Ultimately, you may provide a degree of disclosure that arguably, or in fact does, disclose the name of the employee. However, again, I would not lose sleep if you're providing that information so that your employees can take the necessary steps to make sure that they are healthy and well, or receiving any medical treatment that they might need. That's a classic case of the confidentiality requirements of the ADA butting up against your need to provide a safe workplace. And just as a reminder, you do under OSHA have a general duty to provide a hazard-free workplace, and certainly giving disclosures to employees would be consistent with that goal. Sensitive to time, I'm going to pass on over now to my colleague Dan, who's going to talk about what has happened on the federal level relating to the new leave laws. Dan, are you there and ready to go?
I am. Thanks, Peter. I want to provide a brief summary of the new federal provisions, but I have a couple of qualifications to start out with. One is that we are expecting regulations to be issued interpreting the Act, and in theory, we could see those as early as tomorrow. I think the goal was to get it out within a week of enactment, and the law was passed last Wednesday. So we're hoping that we get some additional guidance, because there are a number of questions that are unresolved, and we're providing our best advice until we see those regulations. The other qualification that I would just add is that under the stimulus bill that is currently being debated in Congress, there apparently are some potential amendments to the Families First Coronavirus Response Act. So it's possible that that new stimulus bill will result in some changes to the law. And we plan to issue some updated guidance once we see both the stimulus bill and any regulations. We'll be sending that out to our client list. And if there's anybody participating today that wants to, that isn't getting our updates directly, feel free to let us know, and we'll make sure you're on the list. One of the issues that has been debated is when the new law, the paid sick leave and enhanced FMLA benefits, will go into effect. And the act provides that they will go into effect no later than 15 days after the law was passed, which would be April 2nd. We believe that the no later than language allows the Department of Labor to decide to decree that it will be effective on an earlier date, but we're waiting to see whether the regulations have a different date. The important thing about the effective date, there's a couple of things. One is that let's assume that it's not effective until April 2nd. If that's the case, then any additional leave that you extend to employees that you don't already provide for as part of your policies, potentially between now and the effective date, potentially won't count toward the 80 hours, the up to 80 hours of paid sick time that the law requires. So, that people should be aware of that and take that into account. In addition, if it isn't effective until April 2nd, there's a question of what happens, if employees are separated between now and the effective date, and whether they will be eligible for the benefit. The general view is that if an employee is laid off or furloughed between now and the effective date, then they likely will not be eligible, unless, of course, they are reinstated to employment or reemployed with new hours later. And both provisions expire at the end of the calendar year. So if somebody's laid off now but then comes back, then they potentially will be eligible for the benefit. So just a brief summary of the benefits that are required under the Act. First, employers, and both of these acts apply to all public employers and private employers with fewer than 500 employees. Both of the benefits allow the possibility of an exemption for employers with fewer than 50 employees. That is an issue that we expect will be addressed in the regulations. So there is some possibility that smaller employers will be allowed to be exempt or to apply for an exemption, and we'll see what that looks like. The paid sick time benefit provides for 2 weeks of paid sick leave for full-time covered employees and partial leave for part-time employees. So that would effectively be, potentially constitute 2 weeks of benefits, paid sick time benefits, over and above any paid leave benefits that you already provide. And for the FMLA benefit, which is restricted, the FMLA benefit in particular is restricted to those who are unable to work due to a need to care for a child that is not in school or not at daycare. That would provide an additional 10 weeks of paid leave beyond the paid sick time, the up to 80 hours of paid sick time that the law provides for. So in all, there's a potential for up to 12 weeks of paid leave under the Act.
Dan, sorry to interrupt. There's two clarifying questions about some of what you're saying right now. One is, are the things that you're saying, is it applicable to full-time employees only or to part-time employees as well? And then a clarifying point on the kids, and I can hold it if you want to answer that question first.
Yeah, it applies to part-time employees as well, and it would be based on their normal hours, daily hours. And if over the last 6 months there's been inconsistency in the number of hours that they work, there's an averaging provision that requires that employers average out the number of hours that they've worked over the last 6 months in order to determine what the level of benefit is.
What about temporary employees?
The Act broadly defines employee, and there is no specific exemption for temporary employees. But if an employer has a temporary employee that doesn't continue to work, so effectively they are furloughed or laid off, then during that furlough or layoff, we believe those temporary employees would not be eligible.
Okay, we might have to go for concise answers because we've got questions coming in like crazy, Dan. Another one that we had is, if folks are staying home, parents are staying home with children because of no school, can both parents take this benefit? And if one parent's working from home, does the other parent have to get paid?
There isn't a restriction on eligibility based on the number of parents who are home caring for the child. So if an employee has a need to be home to care for a child, then they would be eligible. There isn't any provision for determining whether there's another parent at home that would somehow exclude somebody from eligibility.
This is Peter, just for a second as well. You know, the statutes, I had the heads up on that question by just reading it, and the statute talks about caring for the child. Just as Dan says, it doesn't say both parents, one parent. Sometimes the regulations might address some of those issues. So there are probably a lot of what ifs going on with the Federal Department of Labor right now, and it's possible that they might address that type of question. So the regulations, we may be guilty of wishful thinking, but we think that a lot of the questions that we can't answer right now will be addressed through the regulations. They, by the statute, I believe, are due tomorrow. I'm not sure that the Department of Labor are going to comply with the statute, but I think they had to have them out no less than 7 days. Anyway, more, do you want to pose some more of the questions, and we'll take a crack at them, because they look like they're coming through.
I've got a couple more, yeah. Just following up on that, if the FMLA, is it 2/3 pay if caring for a child, and how does that relate to salaried employees?
It would be 2/3 of their per diem rate of pay. I think, again, this is something that I anticipate we'll get some guidance on, but I think the amount of pay would be based on what the salaried employees' hourly expectation is, divided by their weekly salary, and that will determine the amount that 2/3 is calculated on.
Just another clarification. And you know, some of these questions we'll be able to also follow up on that Q&A I talked about. But in addition to this extra sick time, of course, the Family and Medical Leave Act has been expanded temporarily, and the employees are eligible if they work for at least 30 days for you. So the rules that we were all familiar with before under FMLA are certainly greatly abridged. The person just has to be there for 30 days. It would suggest again that all classifications of employees may fall within that. I saw a question up there from, I think, my friend Don asking about relief staff working variable hours who typically wouldn't be eligible for benefits. I think, and Dan, correct me if I'm wrong, even those relief staff may have eligibility certainly for a prorated amount of paid sick time based on that averaging that Dan talked about.
There's a couple questions I'm getting in privately, and so I know you're able to see the everyone questions, and I appreciate you popping in on some of those, Peter. One that I'd like to ask specifically, and this is something that I've seen in my own social circle, and one that has come up in other places too, and so I'll name it out loud. If an employee has a doctor's note to stay out of work for 6 weeks because they're autoimmune compromised, and they've filed for short-term disability and are denied, do they file for unemployment, and how will that affect health insurance?
Yeah, lots of prongs to that. Let me take a crack at it quickly and see more questions. This is my advice on unemployment. Any person should apply for unemployment if there's a possibility that they're eligible. As employers, be careful about telling people what to do and what not to do about unemployment. Certainly you can encourage them to apply, but remember, it's not you who decides their eligibility. So I always caution clients to say, yeah, absolutely, go ahead and apply. These are very challenging times. I can't tell you for sure what the outcome of the unemployment will be. In that type of situation, if a person is out, I think you said for 6 weeks, then they may well qualify for unemployment under the amendments. There's a great question. Can I take one from Mike, who's asked a question about older employees? Because I think when I say it's a great question, that means we have no clue what the answer is, but we'll take a crack at it. Humor doesn't work like it does in a live thing. I'm sorry, please. Yeah, at least you got to laugh at it.
You've got to.
The Mike's question, some of you may see it, is what about older employees with no health issues? Should we require them to go home? And he has some other questions as well. You know, we all immediately hear and you know, the potential for the red flag of age discrimination. Of course, there are CDC guidance saying that people over 65 are the most vulnerable. At this point, I would not be advising clients, and times could change without more assurance from the federal government or the state government that that was legal. I think if we said anybody over 65 has to stay home, you know, we are going to run into a potential certain age discrimination claim. If somebody comes to you and says they're concerned because they're over 65, absolutely, I wouldn't be making them work. Just as someone comes to you and says, I have a compromised immune system, again, I wouldn't be requiring or expecting anybody to work in those circumstances. And in the latter, you're dealing in ADA land and reasonable accommodation and medical leave and those types of things.
I see that Tanya asked a question about the small employer exemption and the eligibility requirements. That's an issue that we anticipate we will see addressed in the regulations. It is the language in the law provides that there can be an exemption allowed by the Department of Labor if the compliance would jeopardize the viability of the business as a going concern. So we don't know whether it's going, if they do provide for an exemption, whether it will be a general across the board exemption for employers under 50, or whether it will be a case-specific exemption. So stay tuned on that.
Yeah, we got a question as well. This is from Andy, who said, could an employer in fact pay more than these mandated amounts, with the consequence being that they're only reimbursed at the statutory rate? And I would say yes. We don't have anything definitive, but it would seem that if you exceed those weekly amounts, that you would still have the ability to seek the payroll tax credit for the statutory amounts. That would seem to be the case. That would, hopefully that it follows common sense. Sometimes the regulations and the law do, and hopefully in that case. And then we got an important question, I think, here. Says, do we understand correctly that any leave we've provided prior to April 2nd does not apply to the 80 hours the feds are requiring? That's a really important question. I think Dan touched upon it earlier. So if you're ahead of the game and you say, all right, we're going to already implement this 80 hours, we just want to do the right thing immediately, and then the effective date of the legislation ends up being April 2nd, it's our opinion that the employee, most likely, again, regs could change it, then has the ability to take that additional or new 10 days based on the effective date. We did see today some guidance that says if you provide it, I believe, well, Dan, did you see the advice on the tax credits? I believe if you provide it before the effective date, you may still be eligible for the tax credits. We should double check on that because it's a fast moving issue. But, you know, I guess in terms of the best compliance and the means to protect yourself from excess liability, it would be best to start providing the benefit on the effective date. And the effective date could be April 2nd and it could be sooner. Dan, have I got that right?
Yes, I think it is not definitive. So again, that's the eligibility for the tax credits remains to be seen.
I'm going to pop in for just a moment, which is to say we've got about 12 minutes left. And so if you have questions that you're holding, folks who are able to view this screen, then if you could type them into the chat box, we will be able to get this to these attorneys at Brann Isaacson so that they can respond to them and we can follow up with you. If you registered for this today, you are going to get a follow-up with a recording of this as well as any additional information that they provide. What I'm actually going to do is take a moment to unmute some of the folks who are on the phone and not able to type their questions. So if you can write your questions into the chat box, please do that. And then I'm going to unmute our folks on the phone. So if you are calling in right now, you've now been unmuted. Is there anyone who would like to ask a question?
Tanya, if we don't have a question as well, I would just want to take maybe 2 minutes. I know we have time for, we'll have more questions, but I do want to just speak to the layoff, the furlough, the reduction in pay issue at a really high level. Again, we could talk about that for an hour. We don't have an hour, but those are the calls I'm getting today, yesterday, Friday. That was the volume of calls. Very reluctantly, employers, but realistically and pragmatically are saying, I can't pay everybody. So what are my options? And, you know, we are giving a lot of advice on salaried pay reductions. And is it possible to reduce across the board the salaried employees? And at a high level, don't take this just to the bank because you should look at it carefully and probably get advice. But at a high level, yes, it is. You shouldn't be doing it. You should be doing it under sort of a plan. It should be more than just an extremely short term, like we're going to do it for today or for tomorrow or just next week. It probably should be longer than that. And don't forget, if you do reduce salaries, you still have to keep salaries above the threshold for the exemption of $36,000. if you furlough salaried employees, then you should furlough them for a week. We have some questions, and we're looking at it more closely about reduced work weeks. There is some Department of Labor guidance on that, but it's far from clear. And then, of course, if you are looking at doing layoffs or furloughs, you're going to weigh whether or not you're going to terminate employment and the consequences of terminating employment versus keeping people on a furlough. Last thing I'll say on that, because there's so much about it, is that what the information we're getting about the incentives that will come from a federal bailout, maybe that if you've in fact terminated the employment of employees, that may impact your eligibility for a bailout. That's very high level. There's more depth to that, but these are all factors that employers are really struggling with, and they're doing so with incomplete information because we're waiting to see what the Congress does. But they all do overlap in this time of crisis. There's way more to those issues, but I wanted to touch upon them on a high level, and I would say they're making up about half of the questions we're getting right now, because people are having to figure out that they just can't meet payroll.
This is an invitation for folks to unmute themselves if you have a question you want to ask. We've got a couple minutes left where we can squeak some more in. I'm furiously trying to record that which you're asking in the chat box so that we have a chance to follow up with our attorneys afterwards. Any questions from you guys?
Hey, Shannon, it's Ellie.
Oh, go ahead, Ellie.
Sorry, I had to unmute. So about the unemployment and sick leave due to the autoimmune disorders, with the health insurance through the employer, how would that work? Does anyone really know how that would really work if I, per se, if I have to file for unemployment because I got denied for a short-term disability? How does the insurance work on that end through my employer?
I don't know the insurance angle of that, and I guess is your question, does that relate to if the employee continues to have health insurance because they continue to be employed?
Correct. So say I have to go because I was denied short-term disability and I need an income and I've used up all my PTO and I have no other source of income until I'm able to go back to work at the company that I'm employed with to find out if I'm still able to get my health insurance even if I'm not getting a paycheck through the employer.
So the modification to Maine unemployment law that was adopted by the legislature just before they adjourned last week provides for benefits in the case of temporary medical quarantine or isolation restriction that is the result of the emergency. So if somebody's unable to work because of those things, then they would be eligible. And they also will be eligible in the case of a temporary layoff due to a partial or full closure of the individual's place of employment. I don't think that the situation you're describing necessarily falls under either of those circumstances, but obviously it would depend on the facts. So I think what you're talking about is somebody who remains employed by the employer, but because of those specific medical issues, they are unable to go to work. And I think that would be covered by existing unemployment law. I can't say definitively whether or not the individual would be eligible or not. So we'd have to look at that more closely.
Okay, thank you.
Somebody just asked about, further information about furloughs, layoffs, and short-term disability. I realize that we can only cover so much in the time, and we really wanted to get to questions too. We are, in fact, going to be doing, Dan and I are going to be doing another webinar tomorrow, and we can always provide people with information about that as well. We may have a little bit more time to spend on that particular topic, because it's becoming more and more pressing. And if folks want to get the alerts we're sending out, can certainly email me or through the chamber, whatever works best, to just let us know, and we just add you to our mailing list. The issue want to touch upon it again briefly, but the WARN Act is a federal law. If you're a mid-sized employer or a large employer, then you're going to pay attention to it if you're doing layoffs. The really difficult thing is the layoffs typically have to be for 6 months. And we all hope and pray that none of the layoffs we're looking at are going to be for a duration of 6 months. But we don't know that. And the obligation to provide a notice under the WARN Act comes when it's reasonably foreseeable that the shutdown of a plant or a facility or a department could be for a 6-month period. So we're fielding questions. Last week, we drafted WARN Act notices for a client with multiple facilities who took, rather, a realistic view, but certainly one that was cautious to say, we need to get those notices out now. We have defended on behalf of clients class action claims brought under the WARN Act, and they're extremely expensive. I don't want to sound like someone who's just talking about legal liability in this time, because safety, safety, safety. But when and if it all, well, when it all passes, all of these issues will be looked at. And when people are out of pocket, lost jobs, lost money, there are plenty of plaintiffs' lawyers who have class action experience who look and see what the potential is. So not to be the gloom and doom person, but WARN Act issues will be important. So if you get our alert on the WARN Act, it's really very detailed. One of the lawyers who litigated the case has drafted it, but we hope you'll find that as a useful resource.
And just by way of clarification on that, when Peter was talking about mid-sized to large employers, the threshold for coverage is 100 or more full-time employees, or 100 or more employees who in the aggregate have worked at least 4,000 hours a week. So if you're in that category and you're potentially looking at employment losses of 50 or more employees as a result of this, then you want to pay attention to the WARN Act issues.
Some of the WARN Acts are being suspended. There's been, Maine doesn't have exactly a WARN Act. There is a Maine severance statute, but that no action has been taken yet. States like California have either suspended or made clear this is an exemption to the WARN Act. But it's definitely an issue to pay attention to. And yes, it's if you have more than 100 employees, but the plant closings, mass layoffs, 50 we're being simplistic about it, and you can see in our publication, but 50 then becomes a very significant number.
So on that front, we're going to have to pause ourselves because we have another webinar starting shortly. I want to first say thank you to our attorneys, Dan and Peter and Mike, who joined us from Brann Isaacson. Those of you with video screens can give a nice round of applause for their time today. Super grateful. I will also say we barely scraped the surface. And so I think there's some really good information we got just in the themes of the questions that are around employer size, number of employees, and clarification over unemployment versus FMLA, and some of the changes with the new Response Act. So perhaps we could send out maybe an FAQ document that compiles some of the things folks had the most urgency for, and we'll follow up. We'll also include a sign up to your alerts so that we can, anyone here who, you're all going to get an email from us with the recording of this webinar, and we'll make sure that we can get any of you who want to get their news alerts. We'll make sure that you have that opportunity, and we'll pass that off along to our friends at Brann Isaacson. I cannot thank you guys enough. I hope everyone got their questions in. An open invitation for you to email us at the chamber to tell us what other information that you would like to be learning or figuring out in these weird times. And to our colleagues over at Brann Isaacson, an open invitation to host more webinars with you. I think there's a thirst for it. And I think there'll continue to be a need as things are fluid, as you pointed out. I can't thank you guys enough, and thanks to the 75 people who joined us today. I think it's a sign of the times we're in, and we will get through this and be stronger together. Thank you, everybody.
Thanks for putting it together.
Our pleasure. We're here for it.
Thanks.
Bye, everyone. Enjoy your day.
Bye.
Bye-bye.